Good afternoon and welcome to this hour-long webinar on the Safeguarding Your Business Guide. In May we refreshed and reissued the guide, and the guide is to, as we will talk about, how you can protect yourself against the insolvency and or insolvency process of counterparties in various different ways. A month after we refreshed and reissued the guide, the UK voted to leave the EU. And whilst the sky hasn't fallen in as many had predicted, things obviously remain uncertain out there at the moment, and we believe the guide becomes even more relevant for that reason. Before I introduce my colleagues, just some housekeeping points. You will see at the bottom of your screen some what we call widgets. Starting from left to right, you have a question mark box if you have any queries as we go along from a technical point of view. Then the slides, there is a media player. The Q&A, if you have any questions as we go along, then please let us have those questions. We will have some time at the end to deal with them, so please email those in, and we will try and answer as many of them as we can within the allotted time. There's the bios then of the presenters, a link to Twitter, and there is also a survey which you are more than welcome to complete about this webinar during or afterwards. So the housekeeping out of the way, let me move on to today's content. And as you can see, myself and various of my colleagues will be presenting to you today on various topics. I am going to start talking about, primarily I'm going to talk about priority, which underlies everything that we're going to be talking about today. But I'm also going to talk about trusts and liens. My partner Nick Moser is then going to talk about retention of title. Unfortunately, Associate Richard Colborne is ill today, so I'm going to be filling in his session talking about security. Associate Catherine Hudson is then going to be talking about directors' duties and how understanding and having knowledge of those duties could help you improve your position if you find your counterparty is insolvent or in an insolvency process. And then lastly, Senior Associate Amy Patton is going to be talking about contractual terms and how you can best protect yourself, particularly once a company has gone into an insolvency process. So I will start talking about trusts and liens. But before I get into that, just to really set the scene as to why all of what we are talking about today is so important. And what is up on the screen is a priority list in relation to who gets paid when on an insolvency process. This is actually based on an administration, but any other process is not going to be dissimilar. And the way this priority table runs is that ideally you want to be up at the top with a fixed charge, and I'm going to be talking a bit later about what that is. Where you don't ideally want to be is down the bottom as a shareholder, because presumably on an insolvency process these shareholders will not recover any money because the company is not solvent. And sitting just above the shareholders are unsecured creditors. What we are going to be concentrating on today is how you elevate yourself from being an unsecured creditor up the priority ladder. The reason for that is a study about 5 years ago on pre-package administrations estimated that the average return to unsecured creditors on an administration is normally between 1 and 3 pence in the pound. So if that's the average return, as you can probably appreciate, a lot of the time there is no return whatsoever for unsecured creditors. So the question is obviously how you can proactively, in an ideal way, prepare for that and try to improve your recovery position in the hope that some money that you might spend now will actually result in a greater return in the future in respect of your position regarding your counterparties, whether they are insolvent or actually go into an insolvency process. One of those ways that you might be able to improve your position is through the use of a trust. And as I've touched on, assets that are realised in an insolvency process are realised for the benefit of all creditors. So once the realisations are made, and once you go down the order of priority I've just been talking about, then the distribution is made on an equal basis to all creditors, and therefore if you are down the bottom of the pile, you will share equally with everyone else in everything that's been realised, albeit after various other classes of creditors. The advantage of a trust is that whilst the asset may be legally owned by the company, it effectively falls outside the insolvency estate because the beneficial interest is held on trust by trustees for the benefit of beneficiaries. And therefore, if the counterparty goes into an insolvency process, the insolvency practitioner will not actually be able to realise that asset for the benefit of all creditors, and hopefully if the trust is valid and works, that asset will be available for the benefit of you as the beneficiary of the trust. From a legal point of view, I mean, this is a whole presentation on its own, as you can imagine, and it's a fairly complex area of law, but you would normally have a trust set up in writing by a set law, which would be the company, administered by the trustees on behalf of the beneficiary, i.e. you. You would need three certainties around the words that are actually used so that it's clear as to what the trust is intended to be created over, the property in the trust, subject matter, and also the object of the trust, what is the point of the trust. But I put up on the screen just some examples as to where you would be using, one slide on, no, one slide back. Some examples at the bottom of the screen as to where you would be using trusts to protect yourself. We are seeing a lot at the moment for clients in the fintech area who are operating platforms that involve the holding of money on behalf of third parties. The clients are asking for our advice on their standard terms and conditions as to how they should actually be dealing with that money in circumstances where it is not theirs or it is not another party's, because if one of the entities in that chain goes into an insolvency process, then there may need to be an answer as to who the money should go to. So if you are handling third-party money, you may well want to consider whether that should be held in trust. If you are, for example, supplying an asset in respect to performance by a company, then you may well want that asset put in trust and held there until the counterparty has performed whatever they are supposed to do in respect to the contract before the asset is released. And the same principle could be used in relation to any payments you are making for performance. Again, do you want that payment held effectively as a retention until performance has been performed? And in the meantime, do you want that payment held on trust to provide you with some protection in case the counterparty goes into the insolvency process and you are still then able to get your money back rather than simply claiming as an unsecured creditor with everyone else? I'm not saying that trusts are going to be right in all circumstances. As I say, they're fairly complex and therefore there may be a certain cost consequence around putting them in place. But there's certainly something that you should bear in mind when starting a relationship with a counterparty as to how you might be able to protect yourself if that counterparty gets into financial difficulty. Another contractual right that you might want to rely on in relation to protecting your position is something called a lien. My colleague Nick Moser is going to talk about the contractual right of retaining title in goods before you have been paid for them. Liens do not actually give you any title in goods that you might have supplied, but what they do allow you to do is to retain possession of those goods until you have been paid. Now often liens created as a matter of law do not actually give you the ability to sell the goods, they simply give you the ability to hold them. And so normally you would need contractual terms to allow you to do that, otherwise you'd have to apply to court to actually sell the goods, which is obviously an expensive way of proceeding. But they can arise through law, but we would obviously recommend, if you think a lien would be of interest to you, that they are included in your contractual terms so that everyone is very clear as to the rights that you have. But for example, if you are operating a warehouse, then there is a common law warehouseman's lien that you can rely on, even if you don't contain it in your contract, but as I say, ideally you would. And so if you have a lien, whether as a matter of law or as a matter of contract, then you have the ability to hold a company's property until you have been paid for it. Now, as Amy will talk about later, administration, which is in the insolvency process I've already mentioned, does create what's called a statutory moratorium, which prevents creditors from enforcing their rights whilst the company is in administration. And so on the face of it, if you are holding company's goods and that company goes into administration, then you are not entitled to enforce your rights by retaining the goods. But as the very incorrect saying goes, possession being 9/10 of the law, from a negotiating point of view, if you are holding company's goods, and particularly there is the ability to create a relationship with the administrators going forward, then that should put you in a very strong negotiating position. And that's exactly what we found for clients a couple of years ago who were storing mobile phones on behalf of a mobile phone distributor. We were the only storage company who could possibly fulfill that function for the administrators going forward, and therefore through our clients' assertion of their lien over the goods, they were actually able not only to be paid in full for what they were owed pre-administration rather than your average 1 to 3 pence in the pound, but they were also able to negotiate a much better contract of supply going forward than the current one they had, simply because their lien was able to increase their negotiating position. So again, I'm not saying that liens are going to be suitable in all circumstances, but it is something to consider as a process that may actually increase your prospects of recovery and put yourself in a better negotiating position if a counterparty gets into financial difficulty or goes into an insolvency process. I'm now going to hand over to my fellow partner Nick Moser, who's going to talk about retention of title.
Thanks, Neil, and hello everybody. So if you are a seller of goods and you're not paid for them, as Neil said, you face getting potentially between 1 and 3% of what you're owed if the buyer goes into an insolvency process. So what can you do to try to avoid being an unsecured creditor that is simple, cheap and quick to put in place and also quick to enforce? Well, that's where retention of title as a concept comes in, and it's, as I've been described on some occasions, a bit of a no-brainer. The idea is that when you sell the goods, you don't actually part with title to the goods, even though the goods have been delivered to the buyer. So it's a contractual concept. And it has real importance for different parties to the transactions and different people who may get involved in the buyer's business. If you're the supplier, then it can impact positively on your credit risk and the ability of you to get to buy cheaper credit insurance, because you will have a better position in the insolvency of the buyer. If you are the buyer, then it can have a negative impact. It might be something which inhibits your ability to raise finance because you aren't able to borrow against the value of the goods that you bought when you don't actually technically own them. And also, as part and parcel of the process of getting retention of title, as we'll see, you may be required to accept the seller's terms of business rather than your own. And so it may not just be retention of title which is foisted on you, but also other terms that you don't really like. But that may be something, depending on this relative negotiating strength, that you can't do anything about. Another impact is that retention of title to be proved requires the supplier to be able to identify their goods. And so you may be required as a purchaser to store the goods in particular ways which you might not be particularly happy about. If you're a lender to the company that is buying these goods, then it could have prejudicial impact on the value of your security, because you might be expecting to have lent against the value of a certain amount of inventory, when in fact, because it isn't owned by the borrower, you haven't got any security. And last, it has an impact on any administrator or receiver who is eventually appointed. And this is really the crux of it, because if you're the supplier, you don't want the administrator or receiver to be able to sell the goods that you supplied but haven't been paid for without them being required to pay you directly what you were owed for those goods. And so the administrator will find that their ability to trade a business and to sell the assets is impacted by the relatively strong power that the retention of title claim gives. So the basic elements of a retention of title claim are the incorporation of a retention of title clause in the contract between the parties, the buyer and the seller, that the clause itself is valid, in other words, that you're not trying to do too much with it, and the sort of thing which goes too far is an attempt to agree that not only will the goods remain owned by the seller, but if the buyer happens to sell them for money, that the money that sits in the buyer's bank account is also effectively owned by the seller. That's an attempt to create security of the type that we were talking about earlier, an attempt to do something which retention of title isn't affected to do, and you need to have registered that security. And lastly, and often the most difficult one, is that you have to be able to identify the goods. It's not just a vague right over a vague quantity of goods which may or may not be sitting in a warehouse. It's a very specific right which needs to be proved. And for example, if you are the sole supplier of a particular type of good to that buyer, then it will be much, much easier to identify your goods than if they've been supplied from multiple suppliers. Likewise, difficulties occur when the goods sitting in the buyer's premises are mixed with others. So, for example, rice mixed with other suppliers' rice will be impossible to separate out. In those circumstances, retention of title claim will be lost unless the two suppliers can club together and bring a class action or a joint claim. So into the practicalities of this, I said in the last slide that a key aspect of the retention of title claim is that the retention of title clause, the wording, is part of the contract between the buyer and the seller. It's not something which can be agreed afterwards. It's something which has to be agreed up front. And so on this slide there are 4 ways in which that can happen. From top to bottom is best to worst. So the best way is to have some form of written contract, a master agreement, or even a credit application form at the outset of the trading relationship will be a point at which, because it's been signed off by both parties, there's an offer to give credit and there's an acceptance of it. And it's at that point where the supplier says, yes, we will supply, but it has to be on our terms, which include a valid retention of title clause. So as long as you can find that retention of title clause in that opening agreement, master agreement or credit application, and it's signed off, you are in the strongest position you can expect to be. And usually you'll find that the retention of title clause at number 7. For some reason, that's the most common number that it's put into. If it's not done at the outset, then it can be achieved by giving notice to the purchaser that you are supplying on those terms if the documentation which is provided during the course of the contract refers to terms on a website or terms which can be found at the premises, or some other very clear way of pointing the buyer in the direction of where they can find the terms which contain a key clause. If that's failed, you haven't done that, then on the delivery note it could say, we're delivering these goods and it's subject to these terms. And last, and this is where you're a little bit desperate, there hasn't been any terms put into the contract at all because of some omission, some error, a mistake. But nevertheless, because you had an agreement previously on a consistent basis and over a decent period of time that your prior suppliers were on those terms, then you can argue that there's been what we call a course of dealing. And so you were just in that rhythm where the terms were always agreed and this last one, for some reason, wasn't, but nobody meant anything by that. So here are some practical steps to take when asserting a retention of title claim. And you'll see that in the first four of these bullet points is the word get. And the important thing is you have to do something. You can't expect to be successful with a retention of title unless at the key point when you're going to enforce it, you are proactive. So first, get to the site straight away. Don't wait to be invited. Make sure someone is there. If it's not you, send someone who is close by who can get there. And when they're there, get an inventory of the goods. Take photos. Require the administrator or the purchaser's representative to sign a copy of the inventory to prove as best as you can that what's there is what you're claiming title over. If an administrator has been appointed, get an undertaking from him or her not to sell the goods without paying you. That's really important. We can provide the exact wording for that. And if you're refused that undertaking, then there are other steps that you can take to try to protect yourself through the courts if necessary. And if needed, because you haven't quite got all the evidence you want of incorporation of the terms, then get statements or helpful evidence from the directors or the purchasing manager of the debtor, the purchaser, as soon as possible, whilst they're still employed and whilst they may still be trying to be helpful towards you. Overall, be proactive. And with that, I'll turn to my colleague, Catherine.
It's going to be me, as I said at the beginning. Richard, unfortunately, is not well today, so I'm going to speak to Neil Smith in his place about security. Nick and I have spoken about various contractual ways that there are to proactively protect yourself against counterparty insolvency, namely trusts, liens, and retention of title. Another way that you might be able to protect yourself is by way of security, and I mentioned at the start of my presentation that if you are a secure creditor, then obviously your ability to improve your recovery on insolvency is much increased. I'll come back and remind you about that order of priority in a minute. But in addition to improving your recovery, you may not necessarily be as aware of the control and influence that you as a secured creditor can have above and beyond simply being an unsecured creditor and recovering your 1 to 3 pence of the pound or whatever it's going to be. And it's a common misconception that security is really only for banks. I mean, anyone can take security. Again, like all of these processes, the circumstances and costs have to be right. But it is potentially a very good way of not only improving recovery, but also taking control of the situation. Before I talk a bit more about that, just to briefly talk about the various forms of security that you can have. In relation to being at the top of the tree and having a fixed charge, you can either have a legal mortgage, which is normally taken over real estate, or a fixed charge which can be taken over any asset class, as long as you can demonstrate that all of the all of the assets over which you are asserting fixed charge, you can actually control at the expense of the borrower, i.e. the borrower is unable to use those assets without your consent. Now that is fairly constrictive and will obviously depend on the circumstances. And if, in effect, you have a fixed charge but it doesn't work because the borrower is free to deal with the assets, that should not be a major issue as long as you have a floating charge. And normally your floating charge would be what we describe as a catch-all floating charge, so it should catch all assets. What is a floating charge? What is a concept that was originated a couple of hundred years ago as a matter of English law, and effectively the charge, as it suggests, floats over any asset class and only crystallises over those assets in certain circumstances. And you'll have seen from the priority ladder that I was talking about at the beginning that obviously a floating charge realisation will give you less of a recovery than a fixed charge realisation, but there are various other options that a floating charge will give you. Before I get into those options, as I said, is it right in the circumstances? You obviously have to have an idea from your counterparty, the borrower, I'll call them in this part of the presentation, as to what assets they have, what their type of business is, and what is viable in the circumstances to allow them to carry on trading their business. But having a floating charge asset over their assets should not prevent them from conducting their business, and therefore should not get in the way of your recovery or their ability to continue to trade. So on the slide is a mini version of what I was talking about earlier. And again, top to bottom is best to worst. So ideally you would have fixed charge security, but still, if you only have floating charge security, that still puts you in a better position than if you were simply an unsecured creditor. How would you go about enforcing your security? Well, your options are likely to be either through the appointment of a fixed charge receiver, the advantage being that that receiver is appointed by you, acts for you in realising assets covered by the fixed charge, and then accounts to you for the proceeds of those assets. That is the advantage of fixed charge receivership. The disadvantage is that it's quite limited in scope. The receiver can only deal with fixed charge assets, is not in charge of the company as a whole, just certain assets, and therefore can't require the consent cooperation of the directors. Alternatively, there is administration, which has been touched on already. That is a collective process, so it is not just for the benefit of the charge holder, although the charge holder can appoint the administrator if they have what's called a qualifying floating charge. But the administrator needs to, or has to act in the best interest of all creditors, not just the fixed charge holder, but does have the ability to step into the shoes of the director and act on behalf of the company. If you have a qualifying floating charge as a secured creditor, then you do, as is described on the chart on this slide, have negative control, in that if the company wants to put itself into administration, if you have a qualifying floating charge, they will have to give notice to you, and whilst you can't stop the actual administration, that will give you the ability to appoint your own administrators. And likewise, in respect of liquidation, whereas that's unlikely, the terminal process to be one that you would initiate under your security, it is the case that if the company wants to put itself in voluntary liquidation, then it has to again give you notice. Again, you can't stop the liquidation from happening, but you could appoint your own administrators as an alternative to take control of the situation. So that's a bit about what you would take security over and how you would actually enforce it, which is the nuts and bolts. But I think the more interesting element to the taking of security is more around the control that it gives you. So it doesn't only improve your recovery, but it also gives you much more control on visibility as to what the borrower is doing, what the borrower intends to do if it is in financial difficulty. For example, if in fact you have been granted security over the shares in the borrower, then potentially you may be able to enforce that security by transferring the shares into a vehicle owned by you. So in effect you take ownership of the borrower. You would obviously need to replace the directors at board level, to actually take executive control. But in effect, what you could do in those circumstances is not only take the benefit of any interest profit on your loan, but also have the benefit of an equity stake in the borrower's business. That is subject to paying proper value for the shares, but if the value of the debt was greater than the value of the assets, then that would obviously go to the value of the shares, and it is subject to policy of what's called self-dealing, which prevents a secured lender from enforcing over and selling assets to itself. So that is easily rectified by using subsidiary structures. Alternatively, if you are less interested in owning the shares, you may be interested in owning the actual assets. If you believe that you can use the assets and trade the business yourself, then subject to paying the proper price, you may want to actually put a bid in for the assets. And depending on the nature of the security that you have over those assets, you may have the ability to effectively bid the amount that you are owed, rather than having to put your hand in your pocket to actually pay cash consideration. That will come down to what security you have over what assets, but these are obviously a number of options that you would not have as an unsecured creditor, but these are doors that are opened if you are granted security by the borrower. And lastly, you may have the ability to control transition of the borrower's business to someone else who is acceptable to you. And a couple of years ago, we acted for a client in this very situation. They had security, they were able to control a pre-packaged administration sale of a distribution business. The distributor was going out of business, was retiring, the business was in financial difficulty, he wanted to sell to a particular party, our client was not happy with that party, and they used the pre-packed system of administration to actually control that sale to a recognised and acceptable distributor. And in fact, I spoke to the client last week in relation to another situation where they took security around the time, a couple of years ago, and are now in a much healthier negotiating position than they would have been if they had been an unsecured creditor in respect of what they are owed. So security is not just about improving recoverability. It is obviously useful for that, but it is also very useful in gaining control and visibility of situations on enforcement. I'll now pass over to my colleague Catherine Hudson, who's going to be talking about directors' duties.
Thank you, Neil. What I want to cover in this section is an overview of the factors that will be influencing directors who are responsible for companies in precarious financial situations, how this might manifest itself in the company's dealings with you as a counterparty, and how ultimately you might be able to use these pressure points to reduce your own exposure. Most of the people listening to this webinar will no doubt be aware of the duties imposed by statute on the company directors. So these include the duty to promote the success of the company, act in good faith and in a manner that's for the benefit of the members as a whole. These duties endure for the entire life of the company regardless of its financial health. However, they are subject to any law which requires the directors to act in the best interest of the creditors. The reason why this is important for directors to bear in mind is because should a company enter an insolvency process, a report may be prepared by the insolvency practitioner which examines the conduct of the directors and, if it's found wanting, may form the basis of disqualification proceedings against those directors. So when does this obligation to act in the best interest of creditors kick in? Well, when it becomes apparent that the company is insolvent, either on a cash flow or balance sheet basis, or indeed both, or within this zone of insolvency that we refer to, which is where the indications are that the financial health of the company is worsening. There's an additional risk for directors of companies which become insolvent from a personal liability point of view. One concern is the claim for misfeasance may be brought against them by an insolvency practitioner who is examining the conduct of the directors in order to ascertain whether anything they've done has caused loss to the company for which they're liable. A claim for misfeasance can be brought against anyone involved in the formation, promotion or management of the company, and so it's actually wider than simply a director and can include shadow directors as well. And it can result in the respondent being made to repay monies or contribute assets to the company to the extent he's misapplied company funds or committed a breach of any duty owed by him to the company. Another potential claim from a personal liability perspective on any insolvency is for what is known as wrongful trading. So the test here isn't in fact focused on whether or not the company was technically insolvent, as many companies trade through periods of insolvency, but whether the directors knew or ought to have known that there was no reasonable prospect of avoiding insolvent liquidation or administration, and didn't take all steps to minimise losses to creditors. So these are the pressures that are on directors of financially unstable companies, although perhaps the extent to which they're going to be aware of them will depend on their level of engagement with the company, their experience, or whether they've taken any steps to get advice. So what sort of things will the director be considering if he's concerned about the financial well-being of his company? Well, first, if they consider that the situation is actually going to be temporary, they might be looking for additional sources of funding to buoy them through these difficult times. As I mentioned, companies can and do trade through periods of insolvency, and those that are particularly dependent on fluctuating markets or third parties and do envisage a recovery might look to this for a potential solution. However, another perhaps temporary symptom of the considerations of directors is the payment of invoices which may become less punctual or might be withheld completely. This can obviously have a significant impact on any supplier company who relies on the timely payment for its own liquidity. Any prudent director will be seeking advice of his lawyers during this period, but the lawyer's remit doesn't extend beyond setting out the legal position and ramifications, and the directors are going to remain responsible for the actual decision-making and its consequences. It might be that the strategically withholding a payment is considered to be in the best interest of the creditors, as choosing to pay one creditor over another will have the effect of staving off insolvency and give them the breathing space that they need to reach a more stable period. Possibly this seeking consultation might extend to engaging an insolvency practitioner in order to ensure that none of its decisions will leave them vulnerable should the worst happen. In order to protect themselves, the directors should be diligent about leaving paper trails in respect to their decision-making process. So this will include the preparation of financial information, maybe consulting with their auditors, and definitely minuting all decisions made during this period. From a director's point of view, this will assist in demonstrating execution of their duties where they define themselves under scrutiny a little further down the line. From a counterparty's point of view, it's worth considering whether to include at the contractual making stage whether the parties have the right to request financial reviews, request an independent audit, or provide financial updates at regular intervals in order to maintain a clear view of the company's position. So a key question for many of those listening is going to be, with all of these pressures on directors, how might you, as a counterparty, use them in order to protect your position? It should be clear from the above that the two concerns for the counterparty are one in relation to their position generally as a creditor of the company and a desire to ensure that the business is being run in a way that won't cause any unnecessary loss to the creditors, and then more specifically in relation to your own particular exposure. So to some extent this depends on how far the problem has actually progressed. If it were more at the concern rather than the crisis end of the spectrum, then it's certainly worth establishing a dialogue with the directors with a view to maintaining transparency so that you too can plan accordingly. Perhaps they themselves are going to proactively engage with you, or perhaps setting up the lines of communication might require a small prod on your part in the form of a reminder of their duties towards the creditor. Again, how subtle you're going to make this prod might depend on the nature of your relationship with the directors, or more to the point, the nature of your relationship with the directors going forward. But at the other end of the scale, it would be referring to the potential personal liabilities of the directors as a company trading whilst insolvent, or the threat that your debt might form the basis of a winding up position as long as it's for an undisputed sum of over £750. This might cause you to be one of the creditors who is paid and another to be the one who has to wait for payment. So if you're able to appreciate these general pressures that are on the director, you can understand how you might use them to your own advantage. But are there any downsides to applying this sort of pressure and getting these results? Well, there are certain transactions that can be unwound at a later date if the company enters into a process. Particularly in this particular instance, one to be mindful of is preference, where an insolvency practitioner can establish that payment was made within the relevant period, and this is 6 months before the company enters into a process, or 2 years if the payment was made to a connected party, that the company was insolvent at the time or became insolvent as a result of making that payment, And finally, that there was an intention on the part of the company to prefer that particular creditor over others. To some extent, however, exerting a degree of pressure on the directors in respect of the debt the company owes you can act as a shield against this requirement to prove the intention to prefer. Because if the company made this payment because they feared you would wind them up, and they were pursuing a strategy that required them to trade continuously, this is not an intention to prefer. If the insolvency practitioner can establish all three elements, then it has the power to unwind the transaction and put the company back into the position it would have been had that payment not been made. So this is just a high-level overview of the duties imposed on company directors, and has hopefully given you a window into understanding what the directors themselves are going to be considering and how this might impact on you and how you might use this to your advantage. So I'm now going to hand on to my colleague Amy Patterson, who's going to cover contractual rights on counterparty insolvency.
Thank you, Catherine. Good afternoon. As Catherine said, I will be concluding the webinar by looking at contractual rights on the insolvency of a counterparty. And I'll be looking both at the right to terminate a contract, but also what your other options might be if termination isn't necessarily the route you want to pursue. So starting with the question of when can you terminate for reasons of insolvency, and there are two general points to make on this. Firstly, the commencement of a formal insolvency proceeding does not automatically terminate contracts by reason of any insolvency legislation. There might be automatic termination provisions in the contract itself, but they're not very common, and they're also not necessarily very helpful because they take away any negotiating ability because termination has already happened. The second general point to note is that the commencement of a formal insolvency process also doesn't suspend your right to terminate. Even where a company goes into administration, which will trigger a moratorium that prevents things like the enforcement of security or the commencement of litigation, nevertheless you are still able to terminate your contract. There is one exception to this general rule, which is if your contract relates to essential supplies, and they include things such as gas and electricity, but also IT services and communications. And if your contract falls into that category, actually your right to suspend or terminate the contract may be prohibited. But other than that, the general position is you can terminate as the contract permits. And that's fundamentally the point. The extent of your termination right, the circumstances in which you can terminate, will be governed by the provisions in the contracts themselves. And this is one area where companies can take slightly more of a proactive role in terms of protecting their position by ensuring that when they're drafting and negotiating termination provisions, the insolvency wording is drafted appropriately. And if you're thinking about the scope of your insolvency termination provisions, there are a few things you can bear in mind. Firstly, think about the terminology that's used. So you would want to be including all of the relevant insolvency processes within that clause. You're also going to want to make sure that the correct references to those processes is used. So by way of example, we will sometimes see bankruptcy of a company in a termination clause as an insolvency termination trigger. That's normally wording that's been imported from the US, where they have a corporate insolvency process referred to as bankruptcy, whereas in the UK, bankruptcy only relates to individuals. So you want to check that the terminology is right. You also want to give some thought to the breadth of the provision. If it's limited to termination being triggered on a formal process, you lose that ability to take any steps earlier than the commencement of a process, which you might want to have. So including things such as the filing of a notice of intention to appoint, which is the step that precedes administration, or calling meeting of creditors, just gives you a little bit more leeway. Wider still is including as a termination trigger the inability to pay debt, and that can be a double-edged sword. It's helpful because it's wider and it may allow you to take steps much sooner than the other triggers. On the other hand, it can be difficult to prove and it can be open to challenge because financial information at companies' house will be historic, and just because one creditor isn't being paid doesn't mean the company is unable to pay its debts. It might just be, for example, that there's a dispute with that particular creditor. Nevertheless, it's probably worth having in there if you can. Obviously, the quid pro quo, if you're drafting your insolvency termination clause widely, that the counterparty might want the same, and so ultimately where you come out with that provision will be a matter for negotiation. In terms of whether you would want to terminate the contract or not for insolvency, this will be primarily driven by commercial factors. If, for example, you have a license agreement and the rights that you've licensed you think are worth much more than what you're getting paid under the contract, then actually the decision to terminate might not be a difficult one. But on the other hand, if you are terminating as a kind of instinctive reaction to insolvency, or because you think that's the best way to protect your position, that might not necessarily always be the case. And actually, if you're on the fence or undecided, it's worth taking advice, but it's also worth speaking to the administrator to understand the state of play in the administration. Because actually, if the administrator is continuing to trade, it might be that they're happy to carry on doing business with you. And if that works from your perspective, then all you would want is either a new contract in place where the administrator is signing as agent of the company, or you would want something in writing from the administrator that confirms that they will pay you any sums due from their date of appointment as an administration expense. And as Neil explained earlier in his order of priority, administration expenses rank very highly, so effectively what that means is you will get paid on an ongoing basis. Also, depending on the importance of the supplies or services that you provide to the company, you may be able to negotiate having the debt that fell due prior to insolvency paid as well. Ordinarily, they would rank as an unsecured claim, and you would just get your couple of pence in the pound, but actually, administrators do have a statutory power to pay creditors in full if they think that doing that will assist achieve the purpose of the administration. Obviously, administrators are going to want to keep those payments as low as possible, so it really will only be in circumstances where they can't get what you are offering anywhere else or for any cheaper. But if you do fall kind of within that category, then it's worth bearing in mind. Finally, if the administrator has sold the business to a third party, you would want to be opening the same kind of dialogue with that purchaser. And here, an important clause to check in the contract is around assignment, and whether your consent to assignment was necessary, because if it was, then that assignment will have been in breach, and the purchaser won't be able to compel you to comply with the contract, so again, you're in a stronger negotiating position there. In terms of how you go about terminating, that will be fairly straightforward. You just want to ensure that you comply with the terms of the contract, and you'd be primarily looking at the notice provisions, so who are you serving, when are you serving, at what address, and you also just want to be aware of any cure periods, although they're not particularly common in an insolvency situation. And the reason why it's important to make sure that you terminate properly is because if you don't, and if either there's a substantive defect because your right to terminate hasn't arisen, or if there's a procedural defect because you haven't served the right notice on the right person, then that will be a breach of contract on your part, and the counterparty may well then look to recover any losses as a result of that breach from you. And then finally, just thinking of any other ways that you might be able to improve your position, we have already looked at security, retention of title, and position as a ransom creditor. The fourth one on the list, and the last one to mention, is the potential for set-off. And this will be useful where there is a two-way business relationship between you and the insolvent party. And what it will mean is that instead of you paying in full to the administrator and then you proving for your debt, you will be able to set that one amount off from the other and then either prove for or pay over, depending on how the numbers work, the balance. And that will therefore allow you a pound-for-pound recovery, which obviously puts you in a much better position. So one important point to note on set-off is that on the commencement of insolvency, any contractual set-off provisions are disapplied and they are replaced by mandatory insolvency set-off rules. And they're quite complicated, but the one thing to remember is they require mutuality of parties. So you need to owe the company and the company needs to owe you. What you can't do in insolvency, which you often can do contractually, is a tripartite set-off, where you can set off from monies you owe the company, monies that that company owes you or your parent or a subsidiary or another group company. That kind of arrangement you can't do inside of an insolvency, but actually if you've just got a straightforward I owe you and you owe me situation, then set-off can be a very useful tool.
Thank you very much, Amy. I'll briefly summarise what we've
heard today, and then we will deal with your questions. But just while I'm doing the summary,
anyone has any further questions that they would like us to deal with, then please send them in to us. We're picking them up live, and we will endeavour to provide you with answers. As Nick and I have spoken about, that there are various ways that you can improve your contractual terms to in turn improve your recovery on an insolvency process. Reviewing contractual terms is not the most exciting thing, and often businesses view it with a certain amount of scepticism when they can easily get standard terms and conditions for a relatively modest price. The prospect of going and instructing lawyers and spending more money is not one that is necessarily at the top of the list. However, it is, I think, a question of potentially spending money to save much more money, in that your standard terms and conditions are unlikely to be specific enough to actually provide you with the protection that you are going to need. And I think it is sensible if someone is looking at it, at the very least from a business point of view, as to where you are, where your counterparty is, what you are actually doing with them, and how terms and conditions can improve the situation, not only on the question of recovery, but generally in relation to the relationship between you. It may not necessarily be that one or all of trusts, liens or retention of title are appropriate. I would suggest retention of title is something that you can include more on a standard basis in trust and lien, and potentially requires less management. But all three of them will need you to be keeping an eye on your trading relationship with your business partners in any event. In addition to that, as I've described on behalf of Richard, security is a very good way of not only improving your ability to recover above that 1 to 3p in the pound or whatever it is, but also to take control of the situation. And we are seeing more and more clients coming and talking to us in relation to the enforcement of security, not along the vanilla lines of, I want to enforce over this asset and sell it, but the more complex and more interesting lines around how they might actually take control of businesses, how they might use security to control the process that they are involved in. Catherine talks about directors' duties. You may feel that your directors' duties is really an issue for the company's directors themselves, but understanding those duties and recognising the leverage that you may or may not have to put pressure on the directors personally, and to move them away from thinking that this is simply a company problem and not their problem, in an effort to increase your leverage position and your negotiation position regarding whatever you are trying to achieve, whether that is better contractual terms or more likely recovery of money. And so it is not just to think that this is an issue for the directors of the counterparty. It could actually be a major benefit and advantage for you if you properly understand the pressures that the directors are under. And as Catherine has touched on, potentially if you are able to assist the directors in that regard, you may well improve your recovery, because it may well be that you are actually assisting the company in turning its affairs around, which should result in a better return for you. And lastly, Amy talked about the contractual terms predominantly as to how you might deal with an administrator, but within that, how actually, in thinking about if you got to that position and dealing with an administrator, what contractual terms you would want to rely on in then working out what you should be putting in your terms and conditions at the beginning of the relationship, obviously anticipating but not hoping for the worst and an insolvency process. So I hope that that 55 minutes or so of content has been useful. Now coming on to your questions, and I'll start with a question for Amy as an extension of what she was talking about. You mentioned negotiating and dealing with an administrator. What's the position of an administrator in relation to complying with existing terms of a contract that you have with that company?
So as I said, if the administrator wants to continue with the terms of the contract, they can do so. The flip side of that, though, is that you can't necessarily compel them to. So if on an insolvency you want to continue trading with the business but the administrator doesn't, the administrator has a duty to act in the best interest of all creditors. And so actually, if he or she looks at that contract and thinks, well, I can get these goods for cheaper elsewhere, then continuing to perform their obligations under that duty, under that contract, wouldn't be in that compliance with their duty. So they are at liberty then to essentially breach that contract and not continue. You would have an unsecured claim for any damages, but we've talked about the value of unsecured claims.
Is there any pressure that you can bring to bear on administrators if you're not liking the way that they are conducting themselves in relation to your contract?
Yes, there are provisions that allow you to bring claims against administrators for misfeasance if you think that they are mismanaging the administration generally. It would be more difficult to bring a claim against them just because you want them to continue with your particular contract. You'd have to be looking at it from a more holistic basis.
Okay. And Nick, you mentioned RAT affecting a purchaser's ability to raise finance, but could it also improve a supplier's ability to raise finance if they actually have valid working retention title in their provision?
Yeah, that's a good question, because I think the answer there is yes. The supplier, their financial position is potentially improved by having a retention title, so lenders tend to look on that positively. Plus, their asset base is larger because they still own certain goods, so there's a possibility of raising finance, extra finance as a result of that. So, retention of title, as I said, is very simple, quick, and cheap to put in place, and relatively simple, quick, and cheap to enforce. So it's why it becomes such an obvious way of trying to safeguard your business in that way.
And you mentioned the practical steps, being as proactive as you can. In your experience, how would administrators deal with retention title claimants who are turning up on site? Do they normally let them on? Is there normally any obstruction? How do those conversations tend to go?
It's normally form an orderly queue. They will be expecting people to come along, and we'll have systems in place to ensure that everyone gets their chance to get their claim in properly. So I would not anticipate any resistance from an administrator, but it's still important to get there first, if only to make sure that you're asserting your claim quickly and get looked at quickly. In my experience from retention of title, you talk about evidence from the directors and managers, etc., that particularly if you are interested in buying their business, then they will tend to be much more amenable to assisting in trying to establish your retention of title claims. Is that your experience as well? Yeah, and if you're looking to buy the business, you'll typically be asked to sign a non-disclosure agreement, which will give you some extra access to the sort of issues that the company that you're making a claim against is facing. And so being involved in that way can also be very helpful.
Okay. Well, thank you very much, everyone. And I hope that webinar was of use. And good afternoon to you.